SJC-13827, Commonwealth versus Domingo, Agostini.
Okay, Attorney Jacobson, whenever you're ready.
Thank you. Good morning, and may it please the court. Haley Jacobson on behalf of Domingo Agostini. I think there can be little doubt that when the legislature first enacted 58A, they intended for armed robbery to be a predicate offense for pretrial detention without bail. And it was under the residual clause until 2019, when this court held that that clause was unconstitutionally vague. In the last 6 years, the legislature could have amended 58A to account for the downfall of the residual clause, but it hasn't.
Can we start with the baseline?
Of course.
The baseline discussion, I think, is what is the least harmful way one can commit an armed robbery? Then we'll go backwards from there.
Yes, I think that's exactly the question that's before this court. And the least culpable armed robbery, or an example of the least culpable armed robbery, would be a person who takes the hat off of someone's head and runs away while carrying a knife in their pocket.
We have the CVS case, right?
The Rogers case?
Right.
I don't think that's the least culpable armed robbery, because in that case, in fact, the knife was used.
And what's the case that you cite for the hat and the pickpocketing while armed, species of armed robbery, correct?
Well, so I would say two things. So one, I don't think that the least culpable armed robbery is a pickpocketing while armed, because this court has said that it has to be enough force, or that the victim has to be aware of the takings, which is slightly different than a pickpocketing. And I don't, to your point, I don't think I have a case specifically about the hat on a person's head, but as this court—
Mora, isn't it? Isn't it the case Mora?
Mora speaks about a very similar circumstance, which is—
Snatching the purse without any person almost being aware of it, right? That's the big case.
That's exactly right, Your Honor. And Mora basically decides this case. I think Mora says that the force required for the least culpable robbery, which in this court gave the example of Jones, where the defendant took a bag off of someone's shoulder and the victim was only barely aware of it happening, that does not involve violent or substantial force as required under the force clause.
How do you distinguish Campbell?
So Campbell, I think, is easily distinguishable on the fact that this court, well, one, it was of course a different offense, and two, I think this court did not simply say in Campbell that it was enough that the rape statute uses the word force. This court looked deeper at what the kind of force used in rape is and concluded that the kind of force used in rape is inherently violent. So it's not simply that force is required for rape, it's that the force required for rape, which is non-consensual sexual penetration, is inherently violent in the least culpable rape. And the same is simply not true. The force used in a rape is simply not comparable to the force used in the least culpable armed robbery, the taking a hat off of someone's head, a bag off of someone's shoulder, or even a book out of someone's hand and then running away. That kind of force is not inherently violent, and it is not violent at all. It is simply the force necessary to take something out of someone's hand who's not paying attention, who's not holding on tightly. That kind of force is not violent or substantial force. It's essentially akin to an offensive battery, which this court has said does not qualify for the force clause. So I also want to address the kind of one element of armed robbery, which makes it different than unarmed robbery, which this court addressed in Mora, and that's the element of the dangerous weapon. But of course, this court has held many times that the dangerous weapon involved in an armed robbery need not be used or displayed at all, and the victim need not even be aware that it exists. So the upshot of that is that for Massachusetts armed robbery, the dangerous weapon really has no effect on the quantum of force used for the least culpable armed robbery. So a person who takes a hat off of someone's head while armed with a knife uses the same quantum of force as a person who takes a hat off of his head and doesn't have a knife in their pocket. So in that sense, Mora controls this case completely because the dangerous weapon element just doesn't make a difference in terms of the quantum of force used for the least culpable armed robbery.
Do you want to sort of anticipate what the Commonwealth is saying the federal law changed after Mora, which may somehow influence us. Do you want to address that argument?
Yes, in fact, that's exactly where I was going next, which is the Supreme Court's decision in Stokeling versus United States. And Stokeling just really has very little effect on this case, and if anything, in fact, reinforces the notion that the force involved in the least culpable armed robbery in Massachusetts does not meet the threshold for the force clause. And that's because in Stokeling, the Supreme Court said that Florida robbery counts as a force clause offense under the federal ACCA because it requires, the least culpable armed robbery in Florida requires force necessary to overcome the victim's resistance. And this court has made clear in Jones, and which the court relied on in Mora, that force to overcome the victim's resistance is not necessary to be convicted of robbery or armed robbery in Massachusetts. And in fact, in Stokeling, the US Supreme Court relied on the fact that Florida robbery did not encompass a snatching or a sudden taking like Massachusetts robbery does. And it was that distinction that the court relied on to say that Florida robbery does meet the force clause. And so for that exact same reason, because Massachusetts falls on the other side of the line, our robbery statute does not meet the force clause even under federal law. So I think this point has, been made clear, but I just want to emphasize that the court's focus is the least culpable armed robbery. Of course, it can't be disputed that an armed robbery can be committed with more force than necessary to take a hat off a person's head or a bag off a person's shoulder. But the focus for this court, because this is a pretrial posture, because this is a question of just has the defendant been charged, can the defendant be charged with armed robbery, the question before this court is the least culpable armed robbery that could possibly be charged in a complaint or an indictment. And here, that least culpable offense, hat off a person's head, bag off a person's shoulder while carrying a knife in your pocket, does not require violent or substantial force capable of causing pain or injury. And unless the court has further questions, I would ask the court to vacate the decision holding, or the order holding Mr. Agostini without bail.
Okay,
Thank you.
Attorney Eisenhower.
Good afternoon, Rachel Eisenhower for the Commonwealth.
Let's jump to this least culpable conduct for now.
Sure, but if I may clear up one thing first, I'm not asking the court to overrule Mora. I'm asking the court to decouple the interpretation of 58A from the interpretation of the ACCA on federalism grounds, because ACCA looks to predicate offenses that can be from anywhere, and because of that, they need a neutral test.
We still have the categorical rule.
Absolutely,
Right? We still
but
apply that in our common law definition of the crime charge, correct?
yes, we have the categorical rule, which is why in 1994, when the legislature enacted 58A, it included the definition of the use of force. They necessarily incorporated the Massachusetts common law, going back to Commonwealth versus Jones, and the element of force within armed robbery, even if we in Massachusetts define that differently than the federal government has defined it.
Okay, so we got rid of the residual clause.
Yes.
All right. Now, into the question I asked, the least culpable or harmful man to commit armed robbery.
Yes, there are a number of examples in the Stokeling case. I like the hairpin out of the hair that takes 3 hairs. That's one of my favorite examples. The facts of Commonwealth versus Jones, the woman's on her hands and knees trying to get the snow scraper out of the car and feels the pressure of the door behind her. So yes, either of those. It is very small force. The Massachusetts Superior Court jury instructions define it as the amount of force necessary to deprive a person of their property against their will does not require the resistance that the Florida statute required in Stokeling.
In the armed component of it, doesn't matter if the victim knows the person's armed.
So I don't concede that no one could distinguish this based on the armed component, but I have not attempted to walk down that road, and I will tell you why. Armed could be either a dangerous weapon per se or a dangerous weapon per used. If it's as used, then you have the assault. the threatened force under the clause. If you have the weapon per se, then what you would need is specific attempt, because it's not actual force and it's not attempted force, or it's not threatened force. So you'd have to fit it into attempt. For attempt, you would need specific intent plus an overt act. Even if you say overt act is carrying it to the robbery, you'd still need to prove specific intent, which isn't part of the crime. So that's my logic.
All right, so if a person calls the police and says, or yells to the police, I was just robbed, and someone takes a hat off the head or does something like that, or the handbag off the shoulder and runs down the street, police catch the person, they frisk the person, and in the front pocket is a Justice George's switchblade that he authorized. Armed robbery, right?
I have to say I'm a little taken aback by some of the facts, but yes, that does meet the elements under the Lattimore standard.
Okay.
I thought I was writing on behalf of the court, but apparently it was just me.
So you're decoupling, I'm trying to figure out what you're arguing now.
Okay,
So
great.
you're saying that, okay, Mora was an ACCA case.
Yes.
And that we should be having a different standard of force under,
So not for every case
I have
under.
trouble following this, so you better.
Sure. Let me
explain this to
explain it. Let me explain.
Nice and slow.
So imagine a world with only 58A and the Massachusetts case law on robbery. There's no Armed Career Criminal Act in the federal system. There's no Armed Career Criminal Act in the state system. There are no Armed Career Criminal Act cases. We have no Johnson, no Stoeckling, no Starks or Parnell, and no Mora. What we would see is a pretrial detention statute where one of the predicate offenses is the use, attempted use, or threatened use of physical force on an elements basis. And we would see case law saying that armed robbery in Massachusetts, or even robbery in Massachusetts, is a crime that this SJC from the 70s has called force. They've used the term force. So the interpretation in that world would be that the 1994 legislature had looked to the state common law and incorporated that definition. So why are we in a different world?
By the way, have we crossed that Rubicon before, or has the appeals court crossed that Rubicon that you don't want us to cross, and coupled? You want to decouple. Have we always coupled, or have we never coupled? I'm just trying to understand.
So the strongest case for coupling is Commonwealth versus Vieira. It's the indecent assault and battery case. And there it was actually at the Commonwealth's invitation that you looked to the use of force clause in the ACCA. And I don't dispute that in a case that didn't have an element labeled force, that it would be a useful thing to look at. Because this language, the use, the threatened or attempted use of force, it runs throughout the federal code, and it is in several places in ours as well. It's become a very common building block for other statutes. And that means that often those are very useful things to look at, but there has to be a context for them that's similar. And sometimes the ACCA context helps. So when the Commonwealth was telling you battery is what the legislature meant by force, we could step over to the ACCA case law and you could look at the battery cases nationwide and assess that and see whether that was good. But here we're saying that state law force meets the definition of 58A force. So we're not.
You want us to walk back Vieira, but not Mora.
So I want you to distinguish Mora and leave it in the ACA context. Mm-hmm. And Vieira, I want you to leave as is too. I want to say that ACCA precedent is useful to the 58A context, but not when the word force is already used so we know what it meant. But if it's not a case with an element of force, explicitly element of force under Massachusetts law, then by all means look to the federal precedent as helpful, to the extent it's helpful. I realize it's been a very long day for everyone. If there are switchblades that are personalized to the justices, I'm interested in having some, but other than that, I will rest on my brief.